Today let us see the transfer of flat. Now when we talk about transfer of flat in a cooperative society, it also includes transfer of shares. So what we had seen the other day in session 3 is regarding the transfer of shares in other than cooperative societies. So now transfer of flat in the case of a cooperative society. So basically there are two methods or there are two ways of transfer. One is we call it as a transfer and another we call it as a transmission. Now transfer is always during the life of the member, during lifetime, and transmission is always after the death of the member. Now when we talk about transfer of shares in a cooperative society, it involves transfer of capital or transfer of right title interest of a flat in the society also. So therefore this transfer always should be backed by a transfer deed. Now what is this transfer deed? Now the transfer deed, or we call it as an agreement, transfer agreement. Now this transfer agreement or transfer deed, naturally either it can be in the form of agreement for sale, wherein the member agrees to sell his flat to another person. When I talk about flat, it talks about the galas, industrial units, or whatever is the plots in a cooperative society. So the agreement for sale, or it can also be a sale deed. Now what is the difference between sale deed and the agreement for sale? In the case of agreement for sale, we are agreeing to sell on fulfilling of certain conditions, whereas in the case of sale deed, which means the entire consideration is received and the flat has been transferred and the possession also has been given. Now there can be another deed, they also call it as a transfer deed, transfer and transferee both do, which is nothing but it is as good as sale deed. So where we are transferring the shares and the right title interest in the property. The next could be a gift deed, where the relatives will transfer the property either by taking certain consideration or without taking consideration, gift deed. So this way there can be agreement for sale, sale deed, gift deed or transfer deed. So these are the various types of documents that is being done in the case of transfer of flat during the lifetime. During the lifetime also there can be another deed which is also called as deed of assignment. Now deed of assignment is done in Pune and other areas where they do for the agreement for sale or sale deed, they call it a deed of assignment. Whatever the right title interest that a particular person has, he transfers his right to another person, they also call it a deed of assignment. Now there can be, let us say there are A and B. Now A is transferring his right to B when it is held jointly, they also call it as a release deed. So release deed also can be done at the time of during the lifetime. So A can release his right title interest in the property in favor of B. So this way either they call it as a release deed or relinquished deed, which means one and the same, where the right title interest is transferred. So this way these are the various documents which requires to be executed, which means one and the same. Only thing, in the case of agreement for sale, there will be later on there will be a possession letter which will be given, and full and payment possession letter also will be given, and also full and final payment receipt will be entered into, which possession letter will indicate as good as is a sale deed. Now this is as far as agreement for sale or sale deed or the documents related to transfer of flat or the right title interest in the property is concerned, and this need to be duly stamped as required under the Maharashtra Stamp Act 1958. So it has to be duly stamped. It also need to be registered. Now any property which has got more than 100 rupees worth value requires compulsory registration under the Transfer of Property Act or under the Registration Act. So therefore it has to be compulsorily registered. So a duly stamped document along with the registered registration receipt and the copy of the agreement also need to be submitted to the society when we are transferring the title. Now in the case of a transmission, what are the documents that can happen? In the case of a transmission, naturally there can be a testamentary document. What do you mean by testamentary document? Testamentary document means documents which is given by the competent court in the particular district. In the case of Bombay, we have a Bombay High Court where there is a testamentary department, which gives letter of administration. Where there is no will, the letter of administration is given for a immovable property, where the administrator is appointed, thereafter he executes the property. The second is in the testamentary document we get a probate. What is probate? Probate is nothing but certifying that a last will of the deceased person, which indicates that whom the property should be getting transferred. So the probate will be made. After the probate is made, if there is an executor, that executor will execute a transfer deed in the favor of the beneficiary. There can be another also, that is called succession certificate. Now what is succession certificate? Succession certificate is normally obtained for the movable properties. What is movable property? Movable property means securities, shares and other things. In case there is in the will, there is a movable as well as immovable property, both are there, then we can obtain a succession certificate. When as on today Mumbai, we have 75,000 as a court fee, which you will have to pay as a court fee, and thereafter the probate can be obtained, which will have a period of at least 6 months to 1 year. Now this is the testamentary document. The other document also can be done is a family arrangement deed. Now family arrangement, in which they will say these are the legal heirs in the property, and that will be duly notarized, and based on the family arrangement, let us say one property has to go to A, second property has to go to B, C property has to go to C, third property has to go to C. In that case, the remaining two people will release their right title interest in favor of A, or whatever is the arrangement. Based on that, release deed will be registered again on the 200 rupee stamp paper, and then of course it will be registered. So this way there can be family arrangement, and affidavit can also be made. There is another way of doing it, that is also called legal heirship. So legal heirship certificate can be obtained from the competent court, either from the district court, and this legal heirship certificate gives us an indication as to who are the legal heirs of a deceased person. Based on that, again you will have to enter into a release deed of the property. So by doing this, either a family arrangement or a testamentary document or a legal heirship certificate, based on that release deed has to be done. With this also the property gets transferred. Now in the case of a transmission, there is another provision which is in the MCS Act, which is very important. This is about the this is as per the Transfer of Property Act. This is the transmission is as per the law of inheritance. Either it is a Hindu law, Mohammedan law, or Indian Succession Act. Now further let us go to the MCS Act. But MCS Act, in the case of a transmission, also provides a nomination. Now nomination under section 30 of the MCS Act talks about nomination. The person can nominate for transfer of the shares. However, the nominee becomes only a trustee. Nominee does not become the owner of the property. At the end of the day, the nominee will have to transfer the property to the ultimate legal heirs. Till such time, the legal nominee can be appointed as what is known as the nominee can be appointed as the provisional member in a cooperative housing society. So this way the properties are getting transferred in the case of a cooperative housing society. Now once the flats or the title interest is transferred, in that case then the question arises, what are the other formalities that need to be done? Naturally, if you go to the MCS Act, section 22 to section 35, we have seen, that is chapter 3 is talking about right title interest of the member. Who can be the member, what are their rights and title interest, or all that is given. Chapter 3, section 35 to 22 to 35. Now this is as far as general law is concerned. Now let us look at the provisions, that is the rules, because every section has to have certain procedural aspect. Let us look at the rules. So if we go to the rules, MCS Act, Maharashtra Cooperative Society Rules 1961, which gives us the procedural aspect of the same thing. So the rules, it starts with, again there is also chapter number 3, page number 540 if you want. So page number 540, where members and their rights and liabilities are Sure. Now, section 22 talks about condition for membership, same as rule 19. Let us come to the rule 19. Again, in the rule, there is a chapter 3 which is talking about members and their rights and liabilities. So, as far as rule 19 is concerned, it talks about conditions to be complied with for admission for membership. So, what are the conditions to be fulfilled? First, it says, no person shall be admitted as a member of a society. No person shall be. So, we have seen the definition of a person. No person shall be admitted as a member of a society unless he has applied in writing in the form laid down by the society or in the form specified by the registrar, if any. Now, when we talk about he has applied in writing in the form laid down by the society, that means it is given in the bylaws. The internal functioning of a society is always governed by the bylaws, so it is given in the bylaws or in the form specified by the registrar. So, the registrar also has specified the application for membership in the bylaws. If you see bylaw number appendix 2 is talking about membership application. So, appendix 2 is about the form of application for membership of a society by an individual. So, this is when a new society is getting registered and thereafter a person is applying for a membership with the various documents, he can give an application and get it transferred. So, in the case of a transfer of flat, again there is a separate form which is given in the bylaws, that is appendix 23 I suppose, where we are talking about in the case of a transfer of shares. Again, when the shares are getting transferred, naturally one can apply for a transfer of a membership, okay, that is given in appendix 23. So, appendix 23 is the form of application for membership of a society by the proposed transferee being an individual. If it is an individual, then form number 23 is given, wherein the applicant, one who has applied for the membership, will sign on that. That is form number 23. Form number 22 is in the case of corporate body. So, in the case of a transfer, this is the form to be applied for membership. In the case of a first membership, that is form number 2, and in the case of same under section 19, rule 19, sub rule 1, form 2 has been specified in the bylaws for new membership, and for a transfer of membership while he is alive, that is form number 23 as far as individual is concerned, that is for transfer. So, when I say transfer, that is during the lifetime, and then if it is a corporate body, that is or the firm, then it will be form number 22. Application for membership by proposed transfer, it is form number 24. Now, in the case of a certificate of sale, see what happens is when the flat is auctioned, it is a mortgage to a financial institution, and the financial institutions sell the flat because they have got the right under the mortgage deed, and by court procedure, by adopting either under a securitization or any other methods, they acquire the property, take the possession of the property, thereafter they sell the property. In that case, the securitization law provides for certificate of sale. Now, in the case of a certificate of sale, what happens is the institution which is auctioning the property or which is selling the property will issue a certificate under the specific law saying that this is to certify that I have sold the property so and so to so and so person which was mortgaged to us, and we have discharged the liability. So, this way certificate of sale comes under the transfer, because that happens during their lifetime. Because here what is the difference between transfer and transmission? In the case of a transmission, the person is not alive. In the case of transfer, the person will be alive, and here it can be voluntarily done by way of agreement for sale and other thing, and it can be compulsory to the act of law, that is by issuing a certificate of sale. So, certificate of sale comes under this one. So, now coming to the form number rule number 19 under chapter 3, rights and liabilities of the member. So he has to apply in writing in the form laid down by the society in the form specified by the registrar. Secondly, his application is approved by the committee of the society. This is very important. That means once the forms are given, now we will list down which forms are required under which provisions, that is later on, but just to specify, there has to be application form. Along with the application form, all the various documents which is specified in the bylaws need to be given. Secondly, his application is approved by the committee of the society in pursuance of the powers conferred on it in that behalf. Now there is a lot of confusion that whenever there is a transfer is happening or a new member is admitted, whether it has to be in the general body or whether it has to be in the committee. So actually the rights lies with the committee. It does not lie with the general body. What happens is, in the general body, they only inform to the general body that during the year so many transfers have taken place, so that they are able to account for the transfer premium they have received and the new members can be introduced. So it is only a matter of information to the general body, but actually the transfer is approved by the managing committee. Therefore it says, rule number 19 sub rule 2 says, his application is approved by the committee of the society in pursuance of the powers conferred on it in that behalf, and subject to such resolution as the general body of the members may in pursuance of the powers conferred on it, and subject to such resolution as the general body of the members may in pursuance of the powers conferred on it in that behalf from time to time pass. That means, and subject to such resolution as the general body of the members may in pursuance of the powers confirmed on it in that behalf from time to time. That means a general body also can pass a resolution giving powers to the managing committee, and at the time of giving such powers to the managing committee to transfer, they may put certain conditions. What could be the condition? The first and foremost condition could be that dues of the earlier members should be paid. The second condition which general body may impose is that the transfer premium of 25,000 has to be paid. So these are some of the conditions which general body may put on certain transfer to be done, and this power is again confirmed on the managing committee, and subject to such resolution as the general body of the members may in pursuance of the powers confirmed on it, in that behalf from time to time pass, and in the case of a nominal or associate member by an officer of the society authorized in that behalf by the committee. That means as far as nominal member is concerned or associate member is concerned, they can be admitted even by the office bearer. That means either they have authorized chairman or secretary of the society, they can also admit nominal member. Nominal member admission does not require to go even to the committee, or even the associate member, they need not go to the committee. Now the next is point number 3. He has fulfilled all other conditions laid down in the act and the rules and the bylaws. If there are certain conditions which are prescribed in the act, rules and the bylaws, that also need to be fulfilled. Now we have seen, or we will see that for associate member in a housing society, they should be the relative, that is the prescribed under the act. In case of a firm, company or a body corporate, society registered under the Society Registration 1860, a public trust registered under the law for the time being in force, relating to the registration of public trust or local authority, the application for membership accompanied by a resolution authorizing it to apply for such membership. Which means in the case of corporate body, trust or association of persons, it has to be accompanied by a resolution authorizing a person to apply for the membership. So this is what is given for a condition to be complied for an admission of membership in a cooperative housing society. Now let us look at, as we were saying, that there are two types of transfer that happens. One is transfer, another is a transmission. So having seen rule number 19, and also let us see what are the other forms which are prescribed under the bylaws. Now as I was saying, there are two types, one is transfer and another is a transmission. Now in the case of a transmission, again it can be by way of a testamentary document or by way of nomination or legal heirship certificates, that is testamentary and other things. The transfer, as I said, there are various documents that can happen. Now let us go one by one. What are the forms required under the bylaws? So the bylaw number 38 prescribes, the bylaw number 38 prescribes the, as far as transfer is concerned, this is given by in bylaw number 38. Now let us go to the bylaw number 38, because rule number 19 says what are the things required to be done. So as we were discussing today, the session is about transfer of flat and the shares in a cooperative housing society. So let us look at the transfer of flat in the case of a cooperative society, and that is related to transfer of shares and interest in the capital property of the society. Bylaw number 38A, notice of transfer of shares and interest in the capital property of the society. So a member desiring to transfer his shares and interest in the capital property of the society shall give 15 days notice of his intention to do so to the secretary of the society in the prescribed form, along with the consent of the proposed transferee in the prescribed form. So if you look at the bylaw number 20, this 38A requires a member should give the notice of transfer, and this notice of transfer is given in bylaw number 38A, which is form number 20 in bracket 1. So the first is notice of, one is notice of sale or transfer, that is 21 and 22. Now 21 is nothing but it's an intention to transfer, and 22 is the consent from the transferee. So this is required. Now 15 days notice has to be given. Now if you look at here, this is also said, if you look at the form, it says as required. I'll just read the letter to the secretary dash cooperative society. I so and so are the member of cooperative society having address so and so and are holding 10 or 20 paid up shares of rupees 50 each, district number so and are holding flat number so and so in the building number so and so of the society, and hereby give you notice as required under rule 24 of the Maharashtra Cooperative Rule 1961 as under. I, we so and so intend to transfer my share, interest, ownership, title, interest in the capital, flat, tenement in the building of the so and our interest in the property of the so and so for a consideration of rupees so and so. The consent of the transfer is enclosed. So that means consent of the transfer is also given. How the transferee consent reads: to the secretary so and so, Sri, Srimati, Messrs so and so are the members of dash cooperative society, proposes to transfer his right, title, interest, shares in the capital property of the society to me or us. I, we hereby give our consent for transfer of shares and interest of so and so in the capital property of the society to me, us, as required under Rule 24 1B of the Maharashtra Cooperative Societies Rules 1961. My and our name and address is as under. Now let us look at rule number 24. So we have seen rule number 19. Let us look at rule number 24. What the rule number 24 says? Rule number 24 is nothing but it's a procedure for transfer of shares. It's a procedure laid down, because the rules always gives the procedure. Procedure for transfer of shares. No transfer of shares shall be effective unless it is made in accordance with the provisions of the bylaws. So that means the rule says it has to be as per the provisions given in the bylaws. Secondly, so you have seen in the bylaws what are the procedure to be done. Bylaw number 38 talks about this transfer. Secondly, a clear 15 days notice in writing is given to the society indicating therein the name of the proposed transferee, his consent, his application for membership where necessary, and the value proposed to be paid by the transferee. That means the intention to transfer need to have an intention whom you are transferring, and 15 days notice has to be given, and the consideration amount has to be there. All liabilities of the member due to the society discharged. That is a third thing. All the liabilities of the transferor due to the society. That means even the dues of the society need to be cleared. And the last is the transfer is registered in the books of the society. That means the transfer also requires registered in the society's books. How it is recorded, we will see later. Any charge in favor of on the shares so transferred will continue unless discharged otherwise. That means any charge in favor of the society on the shares so transferred will continue unless discharged otherwise. Which means many times what happens, there may be certain mortgage, or there can be certain charge created, or there can be dues of the society. In spite of dues being there, even if it is transferred, the entire dues and the liability gets transferred to the new person. That is what the rule number 24 sub rule 2 says. Now this is the transfer document that we are doing, that is form number 20 in bracket 1 and 2 is nothing but it is as per rule number 24.
Sir, what is the why is the consent of the transferee required here?
Now see, a clear 15 days notice in writing is given to the society indicating there in the name of the proposed transferee. Correct?
Correct.
And his consent.
Why is the consent of the transfer?
Because when you tell the society that I want to sell so and so flat to so and so, or I want to sell it so and so, unless until the other person agrees to purchase, then you cannot give a notice of transfer. No? So when you give a notice of transfer or sale, whatever, you have to indicate whom you are selling. Of course, you can always take a, for the sale of flat, if you want to take a open NOC, that you can take a open NOC. But before transferring the shares, his consent is also required. Unless until he gives the consent, then naturally you cannot transfer. So this is as per the rules that is there. So act and rules go with their own logic. We do not have our own logic.
So
It is prescribed in the rules itself. Consent has to be there. Yeah.
So if this condition of 15 days notice is not followed,
Yeah.
and on the same day the same form is given, so whether this transaction will be invalid?
See, there are certain things, as I was saying the other time, if you know, that certain guidelines, certain things are directives, certain things are mandatory. Now these are the guidelines. These are something called a directives. They are not mandatory. Are you getting my point?
Yeah.
There is a difference between directives and mandatory.
Yes.
For example, in RERA, there is a provision. What is the provision? That the complaint has to be disposed of within 60 days. Okay. If you cannot dispose of by writing a reason, you can extend.
Yes.
Correct. So there it is something called directives.
Yes.
This is not mandatory. Within 60 days you have to do it. It is not like that. In the case of application for membership, you have to decide the membership within 3 months.
Right.
That is mandatory. If you don't decide, that is deemed to be the member. So that is mandatory. So there are certain things which are mandatory, there are certain things which are guidelines. Here is, this is a guideline. Now if you don't give 15 days notice, you give 1 day's notice, or you don't give the notice and you sell the transfer, there is no problem. They can be always overlooked by the managing committee. But these are the formalities need to be fulfilled. At least this form has to be there in the record. Many times you have seen all these forms are given at a time, together. They are not given separately.
So there is no issue as
There is no
And
issue.
the transferor does not give. Mostly the transferee after sale of the flat only comes.
That's
and
correct.
submits
See,
all.
these are all practically. So if you don't follow certain rules,
Yes.
rules are always more of a directives or guidelines. So even if you don't follow them, the committee can always overlook. There is no problem.
If we want to challenge the membership, then can we take the reasons which are mentioned?
You can take, but again, as I said, they are all directives. So the registrar may overlook that.
Okay.
You can mention. You can always mention date is not mentioned, name is not mentioned, this is not there, that is not there, the forms are incomplete,
Okay.
and they are not given within the statutory period which is required.
Yes.
So, but if you look at the bylaws,
Yes.
further it also says
Yeah.
that NOC is not required.
Correct.
So that means even if you don't give the intention, it is only you have to give a notice.
Okay.
Okay. Even if you don't give the notice, you don't take the NOC, still it is fine. So let us go to the next bylaw number 38 regarding transfer, which are the next forms required. On receipt of such notice, on the receipt of such notice, the secretary of the society shall place the same before the meeting of the committee held next after the receipt of the notice, pointing out whether the member is prima facie eligible to transfer his shares or interest in the capital property of the society in view of the provisions of section 29(2)(a) of the Act. Now, this provision of section 29(2)(a), what it says, the transfer cannot be done within a period of 1 year. One person has to hold the shares for a period of 1 year. But that is not applicable to cooperative society. So the new bylaws, it will definitely remove this. But otherwise, whether prima facie eligible to transfer the shares and interest, because if there are some litigations, if there are some attachments, if there are other dues. So those can be the condition where we can say that transfer cannot be effected because of these reasons. So section 29(2)(a) is not applicable. In the event of ineligibility in view of the provisions of section 29(2)(a) or (b) of the act of the member to transfer his shares and interest in the capital property of the society, the committee shall direct the secretary of the society to inform the member accordingly within 8 days of the decision of the committee. So within 8 days, the society will inform if there are any issues. Now 38D says, no objection certificate of the society is not required to transfer the shares and interest of the transferor to transferee. Now in case such a certificate is required by the transferor or transferee, he shall apply to the society. The committee of the society may consider such application or merit within 1 month. Now in case the society does not consider within 1 month, what happens? Then you can also go to the registrar on 1st January 2017. There is a guideline issued by the Commissioner of Cooperatives that 1st January 2017, a direction has been issued by the Commissioner of Cooperatives and Register of Cooperative Societies that whatever obligation is required to be done by the committee, if it is not done, naturally by using the provisions under section 79, 1, 2, 3 or section 154B-27, okay, the registrar can give the NOC. So that is the directions or the circular issued by the Cooperative Commissioner on 1st July 2017. So in that case, we can always say that bylaw requires the committee to give the NOC within 1 month, which has not been given. Go to the registrar and take the NOC. Similarly, the transfer and transfer shall submit following documents and fulfill compliance as under. What are the documents? Application in the prescribed form for transfer of interest in the capital property, so along with the share certificate. That means, first and foremost, this form number 21 and 22. Second is form number 21. What is this form number 21? Form number 21 is the application made by the form of application for transfer of shares and interest in the capital of the society by the transfer being an individual. So an individual has to give form number 21. So this is a transfer form, application for transferring the shares. Okay. Of course, form number 22 is for corporate body. Same thing for 22. So if it is a corporate body. Now 23, we have seen that form number 23 is application for membership. Again individual. And form number 24 is corporate body. So that means there is an application for transfer. One is notice of transfer, then the transfer form, and then application for. So application in the prescribed form for the transfer of shares, interest in the capital property along with the share certificate. This is the first thing. Second is application in the prescribed form for membership of proposed transfer. That is form number 23 in the case of individual. Form number 24 in the case of a corporate body. Resignation in the prescribed form by member or transferor. So there is a resignation letter also to be submitted, because membership, not only he has to transfer, he has to give a resignation letter also, which is given in the bylaws. Resignation letter also has to be given. Can you see the resignation letter? Yeah. Appendix 13. Form of notice of resignation of membership of the society by the member. Can you see that? So that means a resignation letter also has to be given. Now it also says, I desire to withdraw from the society and therefore give my notice of 3 months of intention to resign from the membership as required under the bylaw number 27A of the society. Now when you are resigning from the membership, again there is a rule. Now which are that rules for resignation of a membership? Let us look at that rule also. So even in the rules, the resignation of a membership is mentioned. Rule number 21. We have seen the rule number 19, procedure for admitting the member, and rule number 21 is withdrawal of the membership. So withdrawal of the membership, subject to the provisions of Act, rules and bylaws of the society, a member may withdraw from the society after giving 3 months notice to the society, secretary of the society, of his intention to resign his membership of the society. That is rule number 21. No resignation of member shall be accepted by the surety unless the member has paid full its duties, if any, to the society and has also cleared his liability if any as surety to any other or otherwise. Third, the withdrawal of the membership shall also be subject to such restriction regarding the maximum amount of share capital that can be refunded in a year or as may have been provided for the act, these rules and the bylaws of the society. Any member whose resignation has been accepted by the or any heir or legal representative of the deceased member may demand refund of the share capital held by the such member or a deceased member, and the society shall subject to the provisions of subsection 3 of section 29 and subject to the provisions of bylaws refund the amount within 6 months from the acceptance of the resignation or as the case may be the date of demand made by the legal heir representative of the deceased member. In all cases where share capital is to be refunded, valuation of the shares to be refunded shall be made in accordance with the provisions of containing rule number 23. So that means the withdrawal of the membership requires a resignation as per rule number 21, which is also prescribed in the bylaws. Why I am reading bylaws and the rules and the act is that anything which is there in the bylaws are getting inherited or getting transferred from the rules, so that the bylaws does not have something which of its own. So application in the prescribed form for membership of the resignation in the prescribed form, that we have seen form number 13. So that means we have to give, one is notice of transfer, then we have to give application for transfer, then application for membership, third, and the fourth is resignation, form number 13. Okay. Then we have, let us proceed further. Registered agreement with the stamp duty paid, that I have told you, in the case of transfer, whenever we are doing anything, it has to be accompanied with the agreement for sale or sale deeds or relinquished deed, gift deed, or whatever the family arrangement deed with the stamp duty paid. Valid reasons for the proposed transfer. The valid reason for the proposed transfer is nothing but sale,
So
which has been done.
Whether we have to submit certified true copy of registered agreement?
See, self-certification is enough.
Okay.
You want to get a certified copy, that is different, but it is a copy you have to submit. Registered agreement with stamp duty
If there
paid.
is a resolution passed by the society, then
The certified copy can be obtained, but even otherwise Xerox, notarized also will be enough. Undertaking to discharge all the liabilities of the society by the transfer. So that means a transfer form, when he becomes a member of the society, form number 23, it contains that I undertake to discharge all the liabilities of the society. So there is an undertaking which is given. A separate undertaking also can be taken, but right now such undertaking has not been prescribed. Okay. However, there is an undertaking saying that it will be used for the purpose what is required. So separate undertaking is not there. If you look at the form number 22, which is about the transfer, application for transfer of shares interest in that is 23. If you look at the page number 121, para number 9, I undertake to discharge all the liabilities of income. I the undertaking prescribed from the person whom I am dependent to the effect that he will discharge all the liabilities of the society. Okay? So that means he gives an undertaking that whatever is the liabilities, he will discharge. Of course, there is no separate undertaking has been taken, but we can always take separate undertaking if so desired on 100 rupees stamp paper. Payment of transfer fees of rupees 500, remittance of entrance fee of 100 payable by the proposed transferee, payment of amount of premium at the rate fixed by the general body of the meeting, but within the limit as prescribed under the government guidelines, circular issued by the Department of Co-Operative Government of Maharashtra from time to no additional amount towards donation or contribution to any other funds or under any other pretext shall be recovered from the transfer or transferee. No donation or other thing can be taken. Submission of no objection certificate required under any law for the time being in force or order or sanction issued by the government, any financing agency or any other authority. What happens is, if the land is of the collector, that is a government land, or if it is a MADA land, and in that case the NOC as per the lease deed, if the NOC of the authority is required, then you will have to submit that NOC. Or if there is a loan taken, mortgage, the entire land and building has been mortgaged along with the name of the person, so in that case NOC from the financial agency is also required. The undertaking decline in the compliance with the provisions of any other act or rules. So if you look at bylaw number 38, so it will give you any undertaking decline in compliance with the provisions of the any law for the timing in force in such form as prescribed under these bylaws. So that means now income tax undertaking is not required. That section, it was earlier there, but that particular section itself has been done away with. Now that section is not there in the income tax, so therefore that is not required. However, in the bylaws it is still continuing and people are still giving that undertaking, which is not a requirement of the act. See, it says, we enclose here the undertaking and declaration in the prescribed form in respect of the registration of transfer of resignation or transfer of flat to my under section 269AB of the Income Tax Act. What is that 269AB of the Income Tax Act? This was the old sections in the Income Tax Act where the flats are sold at a lesser than a prescribed value, the income tax could acquire. The first right of acquiring the property in a prescribed value goes to the income tax. Now because of the ready reckoner and other valuation methods which are prescribed by the government, and therefore now that section 269AB is not applicable. So that has been done away with. However, in the bylaws that undertakings are still continuing and people are giving that undertaking, which is actually not required. So I think now very important, note the condition at serial number 9, that is transfer premium, shall not apply to transfer of shares and interest of the transfer in the capital property of the source to the member of his family during his lifetime or to his nominee or his legal heir after his death, and in case of mutual exchange of flats among the members. So if it is done during that lifetime, if he is giving a gift deed or to his family members without consideration, in that case the transfer premium is not required to be paid. In all other cases transfer premium is required to be paid. So this is all about bylaw number 38. Now,
sir, taking into consideration certificate of sale is given, and then 38 will come into existence, the transfer.
What is that?
The 38 transfer will come into existence when certificate of sale is issued.
Yeah.
So
in the certificate of sale,
yeah.
here instead of sale deed, there will be certificate of registered agreement likha hai na. That registered certificates of sale deed is enough. Yeah.
So on the place of transfer, whether this institution will be executing the forms or who will be the other person, the resignation.
You are right. In that case, that institution can sign. If the institution is not giving the signature, the forms can be made, and instead of signature, there you can write by way of sale deed.
By way of sale deed.
Or by way of what you call certificate of sale.
Okay, we can do that.
Yeah. Because once again, if you look at bylaw number 55, and we have also seen section 25 of the MCS Act, cessation of member. If he ceases to have right title interest in the property,
yes,
then he ceases to be the member. So having ceased member,
correct,
then the new person can have also apply for a membership directly
under 19.
under section rule number 19.
19.
That also can be done.
Okay.
Okay. Or even bylaw number 19 also is talking about
Yes.
directly membership.
Right.
So that can also be done.
So that won't be a transfer, that would be a taking of a membership.
New membership. Again, in that case, that old membership has to be what you call forfeited. Saying that he has sold, he ceased to be the member, that 500 rupees or 250 rupees share has to be forfeited, a new procedure has to be done.
New share certificate will be issued, no? In that case?
New share certificate will be issued.
That old will cease to exist.
Cease to exist. But normally, if the share certificates are available and these all forms are submitted, then the society can always do the transfer. Because these signatures are not there in a particular form, does not become an invalidate. Because there you can give a form, signature can be said as per the sale certificate.
Right.
Because bank generally do not sign, sir. They are not signing.
Correct. In that case, you can simply write as per the sale certificate. Because sale certificate is through the act of law.
Correct.
है ना? ठीक है?
Okay.
In the case of certificate of sale,
Because they say that they are not
or
transferable.
in case there are certain people who are not available, it also happens.
Yeah. Yeah.
Sometimes people are not available because they sell and they don't sign the forms,
Right.
and then they leave. In that case also you can write as per the sale deed.
Right.
Because in the sale deed always it is written that the right title interest is also transferred,
Right.
already given. So in form number 20, let us say 21, where there is a transfer form,
Right.
the transfer has to
Right.
sign. He is not available. In that case, you can say that the transfer form can be filled and signed as per the sale or agreement for sale. Okay? According to me, I have given number of opinion that even if it is agreement for sale, where there is a payment made, okay, sale deed is executed between two brothers, still transfer premium is not required to be paid, because the note does not say it is only without consideration. It says the condition above shall not apply to transfers of shares and interest of the transfer in the capital property to the member or his family. To the member of his family. So, if he is a family member whom you are selling agreement for sale also, sometimes husband sells it to wife. Okay, so in that case also you don't have
All
to.
comes under the family definition.
Is given
You
in
can
the
avoid.
bylaws. So if you see the bylaws, in the bylaws there is a definition of family. So for different things there is a different definition. So bylaw number 3, okay, if you see the bylaw number 3, I will just give you the 25. Bylaw number 3, page number 13. Family means group of persons which include husband, wife, father, mother, sister, brother, son, daughter, son-in-law, brother-in-law, sister-in-law, daughter-in-law, grandson and granddaughter. These are the family.
But that
For
family
associate
other,
member-
it is different, slightly different.
Associate member definition is
Associate
again.
member is slightly different.
Yeah. Their grandfather,
The son-in-law, no, father-in-law, mother-in-law नहीं है.
father-in-law, mother-in-law. Yes.
Maybe नहीं है, इसमें नहीं है.
In-law नहीं है.
grandfather, grandmother.
Brother-in-law, sister-in-law नहीं है.
Yeah.
Okay. So here brother-in-law, sister-in-laws are there. Daughter-in-law, of course, she is there.
सर आपको थोड़ा ये यूनिफॉर्म करना पड़ेगा सर.
We'll work on this. Now let us come to the next. The bylaw number 39 says disposal of transfer application. The procedure for disposal of the application for transfer of shares and or interest member in the capital property of society shall be laid down under the bylaw number 63, shall be followed by the secretary and the committee of the society. That means a particular procedure also has been given in bylaw number 63. So that we can see later on. Now a meeting of the committee or the general body, as the case may be, shall not refuse any application for admission membership of the transfer and the interest in the capital of the society, except on the ground of non-compliance of the Provisional Act, rules and bylaws of the society or any other law or order issued by the exercise of statutory powers vested in it. So that means ordinarily you cannot refuse the membership unless until certain procedure is not followed or compliance is not done. If the decision of the committee general body, as the case may be, on the application for transfer of share interest in capital of the process is not communicated to the in a 3 months of its receipt, the transfer shall be deemed to have been accepted and the transfer shall be deemed to have been admitted as a member of the society as provided under section 22(2) of the Act. Section 22(2) of the Act says deemed a member, but under section 23(2) you have to file an appeal. Any transfer made in contrary to Act, rules, bylaws shall be void and shall not be effective against the society. That also we have seen under section 25A. Even a removal of membership is possible if the person has not fulfilled. The transferee shall be eligible to exercise the rights of the membership on the receipt of the letter in the prescribed form from the or order under section 22 or 23 of the Act from the registrar, subject to the MCS Act 1960 rules and bylaws. Now, there is once the membership is accepted, naturally you will pass a resolution and make necessary entries in the I form, J form and share register. So once it is done, the society has to issue a letter to the member authorizing him to exercise the rights of the membership. So that is given in bylaw number, form number 26. Form of intimation by the society to the transferee about exercise of the rights of the membership by him. Okay? So upon acceptance of the application for transfer of shares and interest of so and so in the capital property of the society to you, and upon acceptance of the application for membership of the society, simultaneously in the general body of the meeting held on so and so, your name has been entered in the register of member in I form and in the list of member J form, and necessary endorsement of shares held by the transfer to your name has been made in the letter bearing number so. Upon receiving this letter, you shall be eligible to exercise the rights of the membership of the society in according to the Act, rules and bylaws of the said share certificate duly endorsed in your name is attached here in enclosed share certificate. So by attaching the share certificate, you are giving this letter also saying that you are entitled to exercise. So this is how in the case of a transfer of shares, bylaw number 38 to bylaw number 40, one carries on the provision. Okay? Any questions till now?
Form number 26 has to be given by the society only with respect to transfer, and 38 for member or also for provisional member and
all.
member?
It is for all.
All members.
Whenever there is an entry made in the share certificate, you have to.
Yeah. It is applicable to all.
Whenever entry is
Associate
made.
member का तो entry आता नहीं है. But
The associate member also you have to give this letter upon acceptance of.
entry होता है ना.
You can maintain a separate register. Of course, that will come in the rules now. The rules are not yet published. So there is a separate, in the rules it will be mentioned. We will also give a suggestion objection to the government. Okay? So I think up to bylaw number 40 we have seen. Okay. Now let us look at the exchange. Transfer also includes exchange. I forgot to tell you, in the case of a transfer there can be exchange of the flat between two members. So there will be exchange deed between both the parties. In the case of exchange deed, no doubt there will be stamp duty, but the stamp duty will be, let us say, flat number A and flat number B. Flat number A is 500 square foot, flat number B is 600 square foot. Then the stamp duty will be levied on the highest value, only once. If it is same, then only once duty will be levied, because A is exchanging to B his flat, B is exchanging to A his flat. So there will be only one exchange deed, and accordingly the stamp duty also will be one. Second person can retain the certified copy. Exchange deed has to be registered. Now look at this. Now the member desiring to exchange their flat shall make a joint application. So here they can make a joint application to the secretary also containing the following details. Names of the member, you don't have to give all those 38 forms, but you can make a joint application. Name of the member concerned, distinctive numbers of their respective flats, the carpet area in square feet of their respective flat, the building member in which the respective flats are situated, the reasons for exchange of flats. The reason can be anything for their convenience. The procedure for display application for exchange of flats as indicated in the bylaw number 63 shall be followed by the secretary. So bylaw number 63 gives you the various procedures to be followed. Now subletting and all we will see later. Now bylaw number 63 we can always read and understand. We will go to that little later. Now let us come to the transmission. Now the transmission is given in bylaw number 34. Membership, class of members, membership also consists of members, include associate member and nominal member. Now it will not be nominal member, now include associate member, joint member, provisional members. Eligibility of membership of a society, that is as per bylaw section 22, who are the persons who can become member, all is simply repeated here in bylaw number 17. And eligibility of minor member, as minor or a person of unsound mind inheriting shares or interest of the deceased member in the capital of the province, or if nominated may be eligible for admission to membership of the society through his guardian or legal representative of an application in the prescribed form, along with the undertaking declaration in the prescribed form mentioned in the application. Okay? There is a undertaking to be given by the guardian that all the dues of the society will be paid by law. Admission of person to membership of society directly or as a result of transfer of shares and interest of the existing member in the capital property of the society shall be subject to the approval of concerned competent authority, such as collector of the district, and the land granting terms as applicable. As I said, MADA, SRA, SIDCO, whatever conditions are applicable, accordingly the membership will be given. So in the case of a new registration of society, one who applies for an application for registration of society automatically becomes the member of the units in the flat. You have to maintain that. public trust or any other corporate or registered under the law for them are provided under the section 22(1), all this may be eligible to the membership of the society.
Now HUF is also added, no?
Now HUF is also added. However, admission of firm or companies to the membership holding flat by them shall be regulated according to the notification issued by the state government from time to time under the second provision to section 22 of the Act. So under section 22 we have seen the government can come out with a notification. For existing terms and conditions, the government notification referred to above, say annexed to this bylaws. Now, condition for membership, bylaw number 19. An individual who applicant who is eligible to be a member and who has applied for the membership in the prescribed form may be admitted as a member of the committee on applying with the following, complying with the following terms and conditions. So that means that an application has to be given. We have seen rule number 19 also. Applicant has to be fully paid value at least 10 shares of the society along with the application for membership. Applicant has paid the entrance fee of 100 along with the application for membership. Applicant has given the application as prescribed in the particular regarding to the house plot owned by him or any other member of his family anywhere in the area of operation of the society. Applicant has given the undertaking in the prescribed form to the effect that he shall use the flat for the purpose for which it was purchased by him. So in the case of a transfer of share also, this type of undertaking we take. That means the flat which he has purchased, he will use it for the purpose for which it has been purchased. Applicant has purchased undertaking in the prescribed form if she has no independent source of income. Because nowadays, if you want to buy a flat in Mumbai, you have to buy in a housing society only. So the area of operation of the society is
But whether it is same society? Both
same society. Area of operation means same society.
So you have to say that I do not have a flat in the same society.
Yeah, and if you want to buy one more flat, you have to simply give the letter asking for the permission. Okay? This is actually not required now. Because this was applicable earlier when the government used to give the land. MahaSeWA used to give the land. So in the area of operation of society, that means in Mumbai at that time. So if you are owning one house given by MahaSeWA or SRA or CIRCO, then you cannot buy
You cannot apply for another.
Now here those things are not applicable in an open society. Okay. Applicant has submitted along with the application for membership a certified copy of the agreement. Certified copy, that certified copy could be certified by self-certificate or it can be by the notary.
Yes.
It has not been said that certified by the government.
Yeah.
Registered, duly established registered into the promoter builder or transferred under section 4 of the MahaSeWA, Maharashtra Ownership Flats Act. Applicant has furnished such other undertaking declaring in the prescribed form as required under any law for the time in force and such other information as is required under the bylaws of the society along with the application for membership. In case of society registered under the jurisdiction of special planning authority like CIRCO, MahaSeWA, SRA, MMRD, the applicant should be eligible to pursue as per the provisions of respective act and the directive of the government planning authority if any. In case of a SRA, your name should be appearing in the Annexure 2. In the case of MahaSeWA, the MahaSeWA should give the NOC, then only it is applicable. In the case of a collector land, it should be, in the case of MMRD, MMRD should allot the flat. The condition 3, 4, 5, 7 shall not be applicable to the promoter builder applying for a membership of the in respect of the unsold flat. In respect of unsold flat, these conditions are not applicable. Okay? An individual firm or a body corporate registered under the law which is eligible to be an associate member or who shall apply to the member in the prescribed form such member along with the entrance fee shall be admitted as an associate member of the committee by the committee. So that means it is an application to become an associate member. A firm, company or other body corporate under any law for the time which is eligible to be a member of the society and has made an application for membership of the society in the prescribed form admitted as a member by the committee on complying with the following terms and conditions. So what are the terms and conditions for a company? Same thing. What is applicable for an individual? Same thing is for the company. So we have just reproduced that. Now a subletee licensee caretaker eligible to become a nominal member. Now nominal member is not there. So this is now in the new bylaw it will go. Procedure for disposal of the application by the soil laid down under bylaw number 63. Bylaw number 63 has given A to Z. That is a procedure to be followed by the committee for disposal of any application. We will see that. Rights of the member. A member shall be entitled to exercise the rights as provided under the Act bylaws, provided no member shall exercise the rights of the member of the unless he has made such payment to the society in the respect of membership or acquired such interest in the society. So, in order to become a member of the society, he should acquire the right title interest in the flat. Provided further that in case minimum contribution member in the share capital, provided further that in case of increase in the minimum contribution of a member in a share capital to exercise the right of membership, the society shall give a due notice of demand to the member and give reasonable period of time to comply with. In case you have 5 shares, now you want to make 10 shares. Okay, but you have to give sufficient time.
Yes.
And then only you can raise that money. Getting a copy of bylaws, right, audit report, the member of the society has a right to get bylaws, audit report, inspection of books, records and getting copies thereof. This is as per the act only. A member shall have a right to inspect free of cost books, records, etc. as per section 32(1) of the MCS Act and get copies of the document as per under section 32(2) of the Act on payment of the fees prescribed under bylaw number 171. A member shall be entitled to receive a copy of the approved bylaws, audit report of the society on payment of charges prescribed thereof. Member who is deemed to have been allotted flat under bylaw number 75A of the society shall have a right to occupy the flat subject to the terms and conditions set out in the letter in the prescribed form under the said bylaw. See, whenever a new society is registered and members are admitted, naturally an allotment letter is also given to them as per bylaw number 75A. So let me show you the allotment letter which need to be issued to the member on their admission. Okay. So that is there in, there is a format which is given. Page number 100 of the bylaws. Appendix 12, form of letter of allotment of flat to the member of the society. You are a member of the society, registration number so and so, having address so and so. You have purchased flat number so and so, constructed in the building number so and so, advanced so at square meter. The said flat is deemed to have been allotted to you under bylaw number 75A of the society. The flat advising so square meter in so and so building, construction on the advising so and so square stands allotted to you under the provision of bylaw number 75A of the bylaws of the society on transfer of interest in the said flat by so and so to you as approved by the committee general body of the society held on so and so. You may enjoy the right of occupation of the said flat plot under the provision of bylaw number 24A of the society of the society. That means an allotment letter also requires to be issued. Okay? Conditions set out in the general body. Restriction on the rights of nominal member. No associate member shall have a right or privilege of an active member except as per under section 22 of the Act and he fulfills the condition of bylaw number 22A. No nominal member, a nominal member shall have no rights such as a member. Resignation, we have seen a member may resign membership after giving 3 months notice in the prescribed form to the society, as per under by rule number 21(1) of the rules. We have already seen withdrawal of the membership, resignation. No resignation member of the society shall be accepted unless such member has made payment of the charges payable to the society in full. Where any charges are found payable by the member to the society, the secretary of the society shall intimate the name giving full details and reasons of the dues thereof to the member within 15 days of the receipt of the notice of resignation, advising him to make the payment thereof 30 days of the date of intimation. That means as and when charges of the society outstanding with the member, the committee shall accept the resignation of the member and secretary of the society 3 months from the date of receipt of notice of resignation. That also we have seen. Receipt of notice of resignation that has to be given within 3 months. An associate member may resign his membership at any time by writing the letter of resignation to the secretary of the society through the member with whom he held the shares of the society jointly. The secretary of the society shall place the letter of resignation of the associate member before the meeting of the committee held next after the receipt of the letter of resignation, duly recommended by the member for the acceptance by the committee. The decision of the committee accepting the resignation of the associate member shall be communicated by the secretary of the society to the member and his member within 15 days of the decision of the committee. If the receipt of the letter of resignation duly recommended by the committee, acceptance of the committee, the decision of the committee accepting the resignation, if the resignation is rejected, the committee shall record the reasons thereof in the minutes of its meeting, and the secretary shall communicate the same to the member and his associate member within the time specified above. ठीक है?
So that is, now we have to change it to joint.
Yeah. There can be associate member also. Only nominal member is not there. There can be associate member or joint member. If there is no nominal member occupying the flat on behalf of the firm, company or any other body corporate, he may resign his nominal membership at any time by writing the letter. This is not applicable now because nominal member is not there. Sublettee, licensee resignation by the sublettee, licensee or caretaker. Again, it is not applicable because nominal member is not applicable. 31. On acceptance of the resigned member, bylaw number 27, the society shall acquire the right, shares and interest of the member in the capital property of the society and pay him the value thereof as per under bylaw number 64. In case the flat is resigned, he resigns and surrenders the flat to the society, society may pay the money. That is also possible. Okay. In that case, it can be a nominal amount. Okay. Now, why you may be surprised. Now, what happens is, suppose there is a society which is under constructing the building, and you have agreed to buy the flat, let us say for 1 crore. You have paid 25 lakhs. Now 75 lakhs you don't have money to pay. In that case, you can say that I don't have the money now. I am not getting the loan. My job has gone. Now I am surrendering my membership. Whatever I have paid 25 lakhs, after deducting certain charges and all, you pay me my money back. So in that case, the society can sell that same flat to another member. So he may not get a new member. If he gets the new member, it's okay. Otherwise, he will have to surrender. He can transfer the shares or the property after paying all the dues of the society. Because if the society has to receive still 75 lakhs, he will not be able to sell unless until the society gives the endorsement. So these are the things which happens normally. So in that case, society can accept the resignation and pay him the money, whatever is the value thereof. The whole or part of the shares or interest of the member in the capital property shall be transferred in the event of his death. Now if you see this, bylaw number 32, same thing is given in the rules. Let us look at rule number 25. What is given in bylaw number 32 is in the rule number 25. Rule number 25, nomination of persons. For the purpose of transfer of his share or interest under subsection 1 of section 30. Section 30 is about the nomination. A member of the society may, by a document signed by him or by making a statement in any book kept for the purpose by the society, nominate any person or persons. Where the nomination is made by a document, such document shall be deposited with the society during the member's lifetime. And where the nomination made by a statement, such statement will be signed by the member and attested by one witness. The nomination made under sub-rule 1 may be revoked or varied by any other nomination made in accordance with the sub-rule. Where a member of the society has not made any nomination, the society shall, on the member's death, by a public notice exhibited at the office of the society, invite claims or objections, propose transfer of the share and interest of the within the time specified in the notice. After making into consideration the claim or objection received in reply to the notice or otherwise, after making such enquiries as the committee considers proper in the circumstances prevailing, the committee shall decide as to the person who, in its opinion, is heir or the legal representative of the deceased member and proceed to take action under section 30. That means section 30 prescribes the flat should be transferred or the share should be transferred to the nominee or to the legal heir as per the decision of the committee. Now, let us look at the bylaws. Same thing is repeated in the bylaws. Bylaw number 32 says, a member or associate member of the society may, by writing under his hand in the prescribed form, nominate a person or persons to whom the whole or part of the share or interest of the member in the capital property of the society shall be transferred in the event of his death. The acknowledgement of the nomination by the society shall be deemed to be the acceptance of nomination by the secretary. What happens is the nomination also need to be registered in the nomination register. They should give the acknowledgement. It should be recorded in the minutes. But many of times societies, they don't do what they are required to do. So in that case, only the acknowledgement by the society shall be deemed to the acceptance of nomination by the society. No fees shall be charged for recording the first nomination. A member may revoke or revise his nomination at any time by making an application in writing under his hand to the secretary of the society. The acknowledgement of the variation in nomination, subsequent nomination by the secretary shall be deemed to be the cancellation of the earlier nomination. Every revision of the nomination shall be charged ₹100. ठीक है? On receipt of the nomination form or the letter of revocation of the earlier nomination, the same shall be placed before the meeting of the committee held next after the receipt of the nomination form or the letter of revocation of the earlier nomination by the secretary of the society for recording the same in the minutes of the committee. That means you have to record it in the minutes of the committee and also in the nomination register. Every such nomination or revocation thereof shall be entered in the register of nomination by the secretary of the society within 7 days of the meeting of the committee in which it was recorded. Now let us look at the transmission. With this we will conclude today.
सर इसके पहले वाले स्लाइड में it was written member और associate member ऐसा लिखा था ना, तो associate member का nomination का society में क्या effect है?
नहीं now it will be joint member ना.
हाँ नहीं मतलब joint member का
रहेगा ना?
nomination का society में क्या effect है?
Because in the case of a joint holding of a flat, let us say there is a A and there is B, both are holding 50-50. In that case, A, let us say RS Prabhu, this is S Parthasarathy, correct? Both are holding, let us say, shop together. In that case, I will have my nominee, my wife. You may have your nominee, your wife. So each will have inherit their shares. No? Similarly, if there is A is a husband and wife, then husband can nominate wife, wife can nominate husband.
नहीं, but on the
For
death
their
of-
shares.
On the death of B, society में कुछ changes नहीं होगा
होगा ना? On the death of B, because he is a joint member has to be replaced by another joint member. No? His shares are earlier associate member and now the joint member.
But हम लोग कभी किसी ने किया नहीं है सर
नहीं
ऐसा, अभी भी
नहीं किया है तो गलत है.
मतलब करना चाहिए.
Yes. Now A has not expired.
No.
No, B has expired.
Yeah.
Okay. The moment B has expired and he has nominated,
Yeah.
then there will be provisional member.
Yeah, but the
For-
question is whether
It will be
B's membership.
A is a member
Yeah.
and B becomes the joint provisional member.
correct.
Yes.
He becomes a
But
provisional.
वो बनाना ही पड़ेगा हर साल.
हाँ.
Sir, provisional membership is compulsory, right? To
Yeah.
acquire provisional membership.
To acquire provisional membership if you want. Otherwise you can also, without being a provisional member, you can directly make a member. Suppose they make a release deed.
Correct, yeah.
Their legal heirs make a release deed and they make, let us say, C as a legal heir of B.
Hmm.
B's wife is C, let us say.
Hmm.
She and all her children, B's children give the right release deed to C.
Hmm.
Then C can become a joint member status.
Yeah, he will become a joint member. What forms he will be giving? Who will be the transferor?
All the people who are released.
Then in that case there will be a, that is what I am going to discuss now.
Okay.
This is bylaw number 34 and 35. In case of nominal member, provisional member, how it will be done. In case of transfer of membership, how it will be done. Right now we are discussing that. Chalo. I'll answer your question. Subject to the provisions of section 30. We have seen section 30 of the MCS Act. There are two. One is the provisional member in the case of nomination and another is the legal heir by way of a testamentary document. In that case, there will be full-fledged membership. Okay. Subject to provisions of section 30 of the MCS Act, bylaw number 17A, which we read, or 19, on the death of a member, the society shall transfer the shares or interest of the deceased member in the capital property of the society to the nominee or nominees in proportion with the shares and interest held by the deceased member in case the property is purchased by the member and the associate member jointly. In the case of associate member, jointly. Okay. In the event of the death of a member, nominee shall submit the application for membership within 6 months from the date of member. If there are more than one nominee on the death of a member, such nominee shall make a joint application to the society and indicate the names of the nominee who shall be enrolled as a member. Here it is a provisional member.
Okay.
The other nominee shall be enrolled as a joint associate member or that is joint or associate member unless nominee indicate otherwise. Okay? This is only as a provisional member. Now let us proceed. Nominee shall also file an indemnity bond in the prescribed form, indemnifying the society against any claims made to the society, shares in interest of the deceased member in the capital property of the society by the. In case only one nominee is indicated by the nominee or the membership of the society. ठीक है? So there will be an indemnity bond in trust, that is provisional member, until the legal heirs are brought on the record and shall not have the right of ownership and shall not create third party interest or alienation in any way whatsoever. So this is about bylaw number 34 is admitting the provisional member.
बट यहाँ पे सर यहाँ पे इसमें दिया है कि डिसीज्ड मेंबर करके बोला है. So is it applicable only for the primary member?
Member includes joint member. Member includes associate member. Here associate member does not have the right in the property, so leave it. Member includes joint member.
So joint member can be same for.
Bilkul. Okay. 35. Where a member of the society without making a nomination. Now let us come to the where a member of the society dies without making nomination or no nominee comes forward to transfer, the society shall invite within 6 months from the information of his death, claims or objection to the proposed transfer of shares and interest of the deceased member in the capital property of the society by public notice in the prescribed form that we discussed, exhibited on the notice board of the society. It shall also publish such notice in the at least 2 local newspapers having wide circulation. The entire expense of the publication notice shall be recoverable from the value of the shares and interest of the deceased member in the capital property of the society. After taking into consideration the claims or objection received in response to the said notice and after making such inquiry as the committee consider proper in the circumstances prevailing, the committee shall decide as to the person who in its opinion is the heir or legal parent of the deceased member. So in that case the membership gets transferred directly to the legal heir. So now the new act says, section 154B, it says that you have to have a testamentary document. Such person will be eligible to be a member of the society subject to the rules of bylaw number 17, 19, provided that gives an indemnity bond along with as per the prescribed bond, indemnifying the society against any claims made to these shares and interest of the deceased member in the capital property at any time in future by any person. Okay? Now what are the forms required? If there are more indemnity bond along with the application for membership, refer to above. If however the committee is not able to decide as the person who is the heir of the deceased member or the claimant do not come to the agreement as to who shall become member of the society and the interest of the deceased member in the capital property shall be vested in the society. Now what has happened is, now all this procedure is not required, but the claimant has to bring either a letter of administration, succession certificate, testamentary document or a probate or family arrangement deed, then only they will be admitted. This all will go now. Okay? Now what are the forms? Forms are given in the bylaws which you want to see. Bylaw number, let us look at the forms required. Look at the forms. In the case of a transmission, what are the forms to be given? Because you are concerned with that. Form number 15. If you are applying for a provisional membership, you have to apply in form number 15. Okay? Page number 105. The form of application for membership by nominee or nominees. Okay? So the nominee applies and they become the provisional member. In case of a legal heir, that when you want to bring a legal heir directly, in that case, form number 17. Application for membership by the heir of the deceased member of the society. Page number 108. So, in case of a nominee, form number 15. Plus indemnity bond. In case of directly membership, legal heir, then form number 17. Along with that, you have to give the letter of administration.
17 is not for provisional membership.
No.
Sir, membership.
Wait. A nominee is admitted as a provisional member till they bring the proper legal heir. Suppose nominee does not apply, the legal heir directly applies by using form number 17. So then they need not be made. Legal heir means heir whose name the property has to be transferred, as per the probate, as per the letter of administration, as per the section certificate. So in that case, they can straight away apply under form number 17 and become the directly member. Now, there is no nomination. In the legal heir also, there is no document which has come, but by applying this also, one can become a provisional member. I agree with you, because provisional member can be one nominee or in the
absence of nomination.
In the absence of nomination, the committee thinks fit that these are the to certify that this is one of the legal heirs whom we can admit as a provisional member because they are holding the property. They can be admitted as a provisional member. I agree, but normally the legal heir, what we mean is by using form number 17, because even if you admit nominee and when you want to bring a legal heir on the record, then they can use form number 17.
हम लोग क्या करते हैं
But
कि
the legal heir
individually
cannot
हम
be-
2 सेट देते हैं, 38 का सेट 35 का सेट देते हैं, तो 38 का सेट नहीं जाएगा, सिर्फ 35 का सेट जाएगा.
Only this is enough. You
we
don't
give
have.
two sets. We give one for 35 and one for
So
38.
that means, in spite of.
It is not
submitting-
required.
No,
It
And
is
the
not.
38 he becomes a provisional member, and in 38 he himself transfer to him as a member from caretaker to membership. So we give two sets of forms. So this was a confusion. Many of the cases we have seen, the person doesn't apply for provisional membership. Directly he executes a release.
Then 17 is
Only
enough.
17 has to be given.
But in that case then.
17 indemnity bond and undertaking,
Undertakings.
all that.
15 होने के बावजूद भी 17 दे सकता हूँ.
हाँ.
15 है.
Once you have given a nominee,
Hmm.
you mean nominee does not apply.
No, nominee is there, he has applied.
He has applied, he has become a nominal member.
In other legal hires also come and apply through 17?
Yeah,
They can do that?
they can do, provided the nominee also has to resign, na?
नहीं, but ये बोलेगा तो मैं तो legal hair हूँ, मेरा ज़्यादा weightage है.
In that case, his membership has to be cancelled first.
So who will do that, sir?
If there is form number 17, whose job is to bring a legal heir? Nominee's job. That is a provisional member's job. But provisional member does not bring.
Okay.
But what you are saying is provisional member does not bring.
He does not want to bring.
He does not want to bring for some reason. Now the legal heirs are there. They have got a letter of administration. They have got a probate. Then they can straight away under section 17 they can apply, and this society can remove them as a member. Cease to be the member because they are appointed temporarily.
But without testamentary, they cannot come under 17.
No, there has to be 4 documents. One testamentary document, which means probate or letter of administration or succession, one of the 3, or family arrangement deed.
So without that 17 is not possible.
Not possible. How can you?
क्योंकि वो 35 तो बोलता है newspaper advertisement से possible है.
That is possible till yesterday. This bylaw number 35 was as per the old law.
So now we should not say newspaper advertisement के बारे में.
No, abhi karo na. Now that, see, still there is no clarity. Still that rule is continuing because I have read you the rule also.
Correct.
Rule number 25 I have read. If you want me to read once again, I will read. See, where a member of the society has not made any nomination, that rule is still existence.
So bylaw 35 itself will go HS housing society के लिए.
जाना चाहिए, but right now I'm not here to comment how it will happen. But today you can go with the rules. What the rule says, if there is no nomination, just as per bylaw number 35, you can give a public notice and admit them. There is no problem. Okay. But at the same time, Act comes into.
But Act भी इसमें वही बोलता है ना सर. Act भी वही बोलता है कि अगर nomination नहीं है तो legal heirs can be brought on record and made
As a provisional member.
Provisional member, बराबर.
Right now the Act says if there are no testamentary document, it has to be provisional member. ठीक है? Any confusion? So next. So if there is a single nominee, if the demands made by the value of the shares, all this is not applicable now. The society shall acquire the share and pay them value thereof as provided under the bylaw referred above. If in the opinion of the committee there is only one heir legal representative of the deceased member, if the demands made by the deceased, so this is regarding refund. 38 we have already seen, 39 also we have seen, 40 we have seen. ठीक है? So with this transfer of membership is over. Fine? Thank you very much. Now next what we will do is, we will take up the next time very important topic, appeal. That is also equally important, how to draft the appeal, what should be done in the case of appeal. Section 152. 152. We will take the appeal.
Just a request. अजून सुद्धा काही क्वेश्चन्स आहेत जे नेहमी आम्ही डिस्प्यूटमध्ये असतो, आर्ग्युमेंट्स होतात जेव्हा ह्याला जातो एज्युकेशन ट्रेनिंगला वगैरे, जॉईंट मेंबरशिपची आणि मेन मेंबरशिपची. सो ते क्वेश्चन्स आपण नेक्स्ट सेशनमध्ये पण घेऊ.
Okay. Now if you want to take today, we can take.
Not today, we are
Okay.
constrained of the time.
ठीक है. So we will take those questions first,
Yeah.
and then you can send me the questions.
Sure.
So that becomes easier.
Sure,
You can give it to Santosh. He will.
Sure.
put the questions
Okay.
and then we'll prepare a PPT accordingly.
Okay, so if you have any questions related to this
Transmission.
yeah.
Again, whatever we discussed today, we will revisit next time, say for 1 hour, and then proceed.
Sure.
Okay? Chalo, thank you.